friends, how are you? Today I am going to discuss an important topic concerning the discharge versus the quashing. Both the powers are quite different because the power of discharge is available with the consent trial court, while the quashing is the inherent power of the High Court, which is usually available under section 482 of CrPC. So whenever we are going to plan for the quashing or for discharge, which parameter should be borne in our mind so that we could get the optimum result. So in this video we will discuss the basis of the same, the recent judgment of the concerned High Court, which inter alia provides certain guidelines for moving discharge or quashing in the matter under the Prevention of Corruption Act, specifically emphasizing on section 13(1)(b). And in the last of this video I will discuss certain guidelines to be followed in the practical way so that you could obtain the optimum result while arguing your case before the court of law. So whenever you are having the case of Prevention of Corruption Act, you get disappointed that how to fight it. There is no pathway how to fight it. But I want to clarify that if you want to fight your case in an efficient manner, you must be very much clear on the legal perspective and factual perspective. Without clearing on the same, you could not get the optimum result as far as the legal positions are concerned. So please have a pen or pencil and copy with you. Whatever I am going to narrate you, please note down the same and follow this principle and argue your case vehemently. Do not be hesitate while arguing your case. Emphatically argue your case and definitely we will get the result. There is no need to worry before the court of law. You have to very much clear on your brief, on the crux of the case, on the research and on the other scenarios you want to convey to the court in the very easy manner. So make your drafting pinpoint, make your brief in a crux way and argue efficiently. So let's move on the screen. Friends, it is an important judgment pronounced by the Honorable Allahabad High Court. Judgment date is 5th of September 2023. Harsh versus State of UP is the citation. In this case, an application has been filed under section 482 of CrPC, means the inherent power of the High Court is to be exercised for the quashing of the alleged proceeding, that is charge sheet, which is filed in a certain case under section 13(1)(b) of the Prevention of Corruption Act with section 13(2) of the Prevention of Corruption Act. You got the point now? The prayer was made to quash entire proceeding, means the congregant summons concerned with the alleged case number which is pending before the concerned court for adjudication. The concerned counsel had appeared before the court and he has raised the following point. The first point is that the affair was lost by making a false and baseless allegation because no prima facie case is made out against the accused applicant. So if this type of contentions are raised, the burden is on the concerned applicant because he is making the submission that the FIR is false and baseless. So if the specific fact which is the special knowledge of the concerned person, the burden is on him to prove the same. In that case, the concerned applicant is of case that the FIR is totally false, it is totally baseless and it is based on the false and baseless allegation. So in that scenario, the burden duty is on him. So it is submitted that as per prosecution version, the check period taken into consideration by the investigating authority is from 1st Jan 2003 to 29th of May 2017, but the Prevention of Corruption Act was amended in the year of 2018 and the amendment came into effect from 26th of July 2018. The impugned charge sheet has been under the provision of Amendment Act. Placing reliance upon the provision contained in Article 20 subclause 2 of Constitution of India, he submitted that the law which prevailed prior to 26th of July 2018 shall apply in case of applicant, and applicant cannot be prosecuted under the Amendment Act. So in the view of the fact and position of law, he submitted that the impugned charge sheet and proceedings subsequent thereto are liable to be quashed and set aside. The trial court, he submitted that did not consider this important perspective, and that's why the impugned order of summoning the accused is totally illegal, perverse, and it is passed in routine manner without application of mind and referring the legal position. So impugned proceedings are liable to be quashed and set aside. It was opposed by the concerned advocate of the state, but the court considered the entire material on the record. Court submitted that by the perusal of record, it is appearing that the FIR was lodged on 15th of May 2019 against the applicant who is retired as DYSP. The FIR is under section 13(1)(b) with section 13(2) of the Prevention of Corruption Act. It is pertinent to mention here that the court specified and emphasized that this act was already amended in the year of 2018, means 26 July 2018 is an important date from which the amendment has come into motion or has come into effect. Thus, admittedly, the FIR was lodged after the amendment PC Act. So after investigation, charge sheet has been filed under section 13(1)(b) and 13(2) of the PC Act as amended in the year of 2018. It is a basic emphasis of the court. So it is prior to the FIR, but the FIR has been lost as per the amendment scheme. The primary key is that the allegation against the applicant is that while working as public servant in police department during the check period, that is 1st of July 2003 to 29th of May 2017, this is a check period. He had earned more money, means the money more than his legal and known sources, and apart from that, emphasis has been supplied on the acquired assessed, that is more than the legal and known sources, and apart from that, in the conclusion, it is found that everything isn't disproportionate to the known source of income of the concerned applicant accused. The applicant has been summoned by the concerned court to face the trial for the offence under section 13(1)(b) and 13(2) of the Prevention of Corruption Act, and again the court supplied its emphasis on the important fact that the Act recently amended in the year of 2018. The main contention of the counsel is that the check period is prior to the amendment. That's why the proceeding, means the FIR and charge sheet as per the Amendment Act, is totally illegal and liable to be quashed and set aside. Before proceeding further, the court also emphasized on section 13 before amendment, and specific provision has been made in section 13(1)(e) to deal with such type of offences, and after the amendment 13(1)(b) has been incorporated which deal with that issue. So the court specified that the cardinal principle of interpretation is that every statute is prima facie prospective unless it is expressly or by necessary implication made to have retrospective operation. So it is a basic guidelines even by the Honorable Supreme Court as far as the pronouncements are concerned. Every pronouncement shall have prospective result, should not have the retrospective result. So generally it is considered that every statute dealing with the substantive right is prima facie prospective unless expressly it is specified. So it is submitted on the behalf of the applicant that whereas in the pre-amendment provisions of section 13 the word intentionally was not there. So amendment of section 2018 specified that the act should be intentional. So it is clear that the amendment which is specified the changes in the act itself, these changes cannot be said to be mere procedural. In as much as under the amendment provision, the prosecution has to prove the intention. If the intention is not proved, in that scenario, in the easygoing manner, in the routine manner, the concerned agency could not affect the substantive right of the party unless and until they prima facie consider and specified that act has been done to enrich himself. So these are the basic criteria, a basic differentiation between 13(1)(e) and 13(1)(b) at this stage. So the court specified that if before the amendment we are going to emphasize on section 13(1)(d) also, it will be clear that it specifies that if a public servant for himself or for any other person has acquired at any time during the period of his office any valuable things or pecuniary resources which is disproportionate to his known source of income, in that scenario he will be punishable under section 13(2) of the PC Act. So it is clear that in section 13(1)(b) intention is necessary, but it was not the necessary ingredient of section 13 before the amendment. So this is a basic differentiation between this section. The court has specified that in the instant matter the allegation made against the applicant is that while working as a public servant he has obtained more than his legal source. But the key point is that the impugned charge sheet or proceeding cannot be quashed on the technical ground that check period considered by the investigating authority related to the period when pre-amended PC Act was in force. So further, the applicant may raise his plea before the concerned trial court at this stage of charge. The legal position is quite clear. While moving for the questioning, you have to satisfy to the court that no prima facie case is made out. So if it is on technical ground, it is better that you should move before the concerned trial court in the discharge petition. So in this case, the court disposed of the petition with the ground and liberty to the concerned applicant that he is given the liberty to move before the consent court with an application for discharge, and the court will adjudicate and will consider all the issues. So court specified that till disposal of this application no course of action shall be taken against the accused applicant. So by the bare perusal of this entire scene we are of following conclusion. Number one, if we are moving for the questioning, we have to specify that no prima facie case is made out. We have to emphasize on the uncontroverted fact, but we are moving on technical ground. In that scenario, rather than to move directly to the High Court for the questioning, it is a better remedy that we should go for a discharge petition. So this citation inter alia enlighten us, inter alia clear all our doubts whether we should move before the High Court or before the trial court on the technical issues. If there is those facts which are uncontroverted, and even though they are taken at their face value as a gospel truth and no case is made out, in that scenario you are advised to move for the questioning. And if the case is made out and apparently you are emphasizing on the technical issue and charge is not framed, in that scenario you could move before the concerned trial court for the discharge petition. And last point which I want to clarify with you, if your petitions are pending on such grounds, it is better that in light of that judgment, rather than to have a proper dismissal, request to the court with a liberty to be granted to you, that in case the application for discharge is moved, the trial court is to be directed to consider the same on the merit. So in that scenario we could easily create a pathway and could easily submit our contention in the very easy and fantastic and the legal manner. So it is a legal update for you. For such update, please follow my page, subscribe my channel for such type of video. Friends, see you in the next video. Till then, Jai Hind, Jai Bharat.